All right. Is there anyone that needs to call his or her case out of order because you have somewhere else you need to go? If not, I'm just going to work my way down the docket in the order in which it was given to me.
Judge, this is Rich Alexander. I don't have anywhere else to go, but you've got on the docket the Jones versus Hicks case for
Yes, sir.
review today. Mr. Basil provided the affidavit that he and I talked about, so that case can go ahead and be dismissed as to Wesley Hicks in the estate of Charles Hicks.
Very good. I believe I have an order in the e-filing queue that I can sign after we get done here this morning. Okay.
If you don't have an order, Your Honor, I'll provide one. Just let me know.
Yeah, we'll let you know, but I know I've seen the order. I've seen a hard copy of it. I'm pretty sure it was in my e-filing as well, but either way, we'll get it.
Thank you, Your
All
Honor.
right, thank you, Judge.
Thank you. All right, next on the list is 18 CI 687, Kentucky Farm Bureau. It's a subrogation case versus Wilson. I believe this was filed by Mr. Miller from Campbellsville. I do not see him on here. Does not appear to be anybody asking to cover that, so we will move on. Crown Asset Management versus Metter, 19 CI 475.
William Rick on behalf of the plaintiff.
Yes,
This is our
sir.
motion to set aside the dismissal for lack of prosecution, which was because of the error on behalf of the plaintiff's firm. We allowed it to be dismissed. The defendant has been served. We do want to proceed with a motion for default judgment.
Okay. Yeah, I think that one was probably attributable to pandemic-related confusion as much as anything else. It's not the first time that we've had something similar, just where nobody knew whether we were going to be in court or not in court and that kind of thing. I believe under the standard that I should approach that in, that there is no prejudice, that defendant has not appeared. There isn't any defendant hadn't taken any steps, even though there's proof of service in the record. So I'm going to grant the motion to set that dismissal aside. Mr. Rich, you may have not filed. I don't believe you were the original filer. I don't know if they've tendered an order electronic.
They did
Not.
It's attached to the motion. It looks like it's maybe in between the motion and the notice, but it's in there. I'm not sure where it's in the images, but it should be in the images in CourtNet.
All right. Well, we'll try to track it down. I mean, obviously nobody's in there in the courthouse at this point, so
Sure.
we'll try to track it down and get it entered at some point if it's not in the e-filing. Okay.
That's fine. I can email you a copy, Judge, if that'd be easier.
Well, we'll let you know if we need it.
That's fine. All right.
Okay. All right. Thank you.
Thank you. Have a good day.
You too. 19 CI 488. That is the Mildred Knoll case versus Asset Recovery and various other entities. This is a motion to by the purchaser of property at a courthouse door type sale, that there were some issues and the purchaser wants to rescind, I suppose, the sale. There's also a motion to amend the complaint, or cross complaint maybe, which would, I think, address some of the issues. Doesn't help the purchaser out on the front end here, but it would address some of the issues. Does that sound accurate?
It is, Your Honor. This didn't start out as a case that was intended for a master commissioner's sale at all. It was intended as a quiet title action regarding a mortgage, and for that reason, I don't think some of the background work that needed to be done in order to actually do a complete master commissioner sale was done. The issue for my client is he's got money tied up in this, and you know, we have a whole lot of liens against the property that were never addressed. So that's why we moved to set aside the sale. Now, if there's a way to address this quickly, I think my client's happy to keep the property. It's just he doesn't want his money tied up for a long period of time while this is getting straightened out. So,
Sure.
and I know most of these are liens to the medical center. Mr. Hodges is always very easy to get along with when it comes to dealing with these kinds of things, but there are also liens to, I think, Discover Credit Card and some entities that we have a lot more trouble dealing with. So.
Right. And I mean, from my perspective, the original motion, which is your motion, you know, I don't see any way that should not be granted. I mean, you know, you purchased property at a sale, and like you said, everything that was supposed to be, that would have normally been, all the defendants that would have normally been in there because they have an interest in the real estate by virtue of a judgment lien or otherwise were not noticed on the original action. So that, you know, that's unavoidable from my standpoint, you know, as far as your purchaser is concerned. It also seems fair to allow the amended pleading to go forward, but I'm not sure that addresses all of the issues that you have raised, because I didn't read all the way through it. I just know that they wanted to amend it, and the purported reason was to address the concerns that you had. I don't know that it addresses them all. For example,
one of the things that would,
yeah,
sorry,
one of
Your
the
Honor,
issues that you raised was about that one or more litigants had passed away during the time that this action was pending. And I'm not sure that the amended pleading addresses anything about those estates. If it does, then all to the better, but I'm not sure that it did.
Your Honor, this is Justin Duncan. I'm here on behalf of Asset Recovery, standing in for Mr. Shadowan, who's unavailable right now. So
Okay.
I've read through the pleadings, and I think we agree. I don't think there's any defense to setting aside the sale. I know that attached to the motion for leave to file an amended counterclaim is the first amended counterclaim, which looks to name all of those entities that Mr. Basil has identified. As far as the estates, I'm not sure what's going on there. I can run that by Mr. Shadowan and see what he thinks, but that seems like it's something that would have to be addressed as well.
Yes, sir. And I'm not promising that it wasn't in that first amended counterclaim. I wasn't reading it for that purpose. I basically just read the motion and realized what the it's not up to me to decide the adequacy of the allegations in the counterclaim. It's just up to me to decide whether a party ought to be able to amend their pleading, and under the circumstances, you certainly should. So as far as answering that question, that's fine. And I will answer that in the affirmative, and we'll allow that counterclaim to go forward. But I was just pointing out I didn't realize that's what you were here for, because I was expecting to see Mr. Shadowan, but I was just pointing out to Mr. Basil that I wasn't sure if it addressed all of his short-term needs, because apparently his client wants to, is still interested in pulling the trigger on this if it can be done pretty quickly. But I can't control that. That'll be something that everybody has to talk about outside of the confines of this hearing.
Right. And I think that's probably a win-win for everybody if that can be accomplished. So we'll get in touch with Mr. Basil and see what we can put our heads together and see what we can get done.
Okay.
I think
but
part
for
of
the
the
record,
part of
Yeah,
the
go ahead.
solution to this, Your Honor, there's a pool of money sitting out there, and the issues with the judgment liens is really about the division of that money and the severance of any claim against the property. So if we can work something out on that and go ahead and get these estates served, that might satisfy everything.
Sure. Well, like I said, from my standpoint, I'm granting your objection, I guess is the way, or I'm not going to approve the sale because your objection is well taken. I'll grant the motion to amend the counterclaim, and then I will just sit back and wait for whatever else you all need me to do going forward.
Okay,
Okay?
Thanks, Your Honor.
thank you, Your Honor.
All right, thank you. Wells Fargo versus Froge. That is simply a motion to dismiss. It was noticed, I guess, in case anybody felt like objecting to it, but I didn't expect anybody to, so I'm going to sign that.
Thank you, Your Honor. Travis Thompson on behalf of Wells Fargo.
Yeah, you don't disagree with me, do you?
I'm sorry?
You don't disagree with me, do you?
No, sir.
All right. Well, feel free to, but I just mean from the standpoint of whether your motion will get granted. I'm planning on granting your motion unless you talk me out of it.
Sounds good, Judge. Thank you very
All
much.
right. Thank you.
Have a good day.
20 CI 255, Wilmington Savings Fund versus Vance and others. That looks like a motion to substitute a named party because there's been some sort of debt-related transaction. It sounds like I don't see anybody on here, but that's kind of perfunctory. I don't have a problem granting that either. Kentucky Farm Bureau versus Felty, another subrogation case. I see Mr. Felty may be on here. That's the same plaintiff that did not appear in the Kentucky Farm Bureau versus Wilson case that I called at the top of the docket. So I anticipate, since I recognize everybody else that's on this Zoom meeting except Mr. Felty, I assume that Mr. Miller is not here for that case as well. That case is going, or that motion will not be granted, particularly because there is a defendant here. Mr. Felty, can you hear me?
Yes, sir.
Let me tell you what's going to happen here. All right. This action has been filed and it doesn't appear. What's all that? Is that you? Yeah, do this. Let me tell you what I want to tell you, and then if you need to get on here and turn your mic back on to ask me any questions, you can. But this complaint has been filed and it was served on you back in June of last year. Typically, you have 20 days to file a written response with the clerk if you have been sued. And if you don't file something within that 20-day period of time, the other side is able to ask for a judgment against you, which is why we're here right now. It gets pretty technical once you miss your time frame, which it appears that you did, because I don't see anything in the record that shows that you filed anything. For you to file any sort of response at this point and keep a judgment from being entered against you, you have to request permission from the court in writing to file a late answer and explain to me why you didn't file one in a timely fashion. And we would probably need to have a hearing on that to decide whether I would allow you to file a late answer before I could take up the question of whether or not I'm going to give them a judgment because you didn't answer. I don't know if that makes any sense or not, but that's why when you get sued, you get a piece of paper that says you must file an answer within 20 days. I'm going to assume that you got that because the person from the Barron County Sheriff's Office that serves those papers signed one saying that he handed it to you, and it has been filed in the record. So the point being that if you don't want to get a judgment against you for the money that they're claiming, the two options that you would have at this stage would be A, to try to get in touch with the attorney that filed this motion and see if you could work out something with them, or B, either with an attorney or by yourself, file a motion with the court for permission to to file your answer, even though it was due 8 months ago or 7 months ago. And if you can convince me that you have a good reason for not answering and that you have a potentially meritorious defense, then I may let you file a late answer. Okay? Does all of that make sense?
Yes, Your Honor.
All right. So, but for the purposes today, because that attorney did not appear to argue his motion, I'm not going to grant the motion. So there will not be a judgment entered against you today. Okay?
Yes, sir.
All right. And then just, be sure that your address is current with the clerk, because, there may be something else filed and you would, you need to, if your address has changed, you need to send something into the clerk to let them know so that they can change it, in the record and send a copy to that other attorney. I assume that you've got the same address because you were aware of this motion, but that's the number one thing that tends to happen when people don't show up to things. It's because they've moved and nobody knows where they are. Okay.
Yes, sir.
All right. Thank you very much.
Yes, sir.
All right. I think that is the civil docket. Does anybody have something on the civil docket that I don't have? I guess, Mr. Rogers, you're here for the 10 o'clock. Scott's still on. I guess he's here for the 10 o'clock. Or he just hadn't gotten out.